Before resuming debate, I must tell the honourable member for Abitibi-Témiscamingue that I will have to interrupt her at 2 o'clock when it will be time for members' statements. So she has about 10 minutes. The honourable member for Abitibi-Témiscamingue.
Merci beaucoup, monsieur.
Thank you very much, Mr. Speaker. I'm very pleased to rise today to speak about the bill to amend the Criminal Code, the Canada Evidence Act, and the Security of Information Act. This is a bill that is part of a whole series of anti-terrorism pieces of legislation that started in 2001 after the September 11th attacks in the United States. Bill S-7, the Combating Terrorism Act, is intended to reintroduce anti-terrorist measures into our criminal justice system. And you have to understand that these measures have been controversial from the outset in 2001. I think that we have to understand here that these measures that were introduced in 2001 were a response to a really panicked moment in time. I think everyone considered September 11th, 2001 as a signal event in their lives, and there was a kind of panic. People didn't know how to react to those attacks. And I think that if I took the time to ask all of the members present in this House, I think everyone would be able to tell me where they were sitting, what they were doing when those attacks took place. Personally, on September 11th, 2001, I was 17 years old. I was starting my college studies in nursing. I was in my psychology class, and the professor came in to announce to us that there had been these attacks in the United States, and that there was an attack on the World Trade Center towers. One of the students panicked and said, "My mother's in New York right now," and so therefore, yes, there was that panicky reaction, and we all know exactly where we were and what we were doing. Another example, when all of this happened, well, as I said, I was in my first year of nursing in Sherbrooke, so that is closer to the U.S. border than some other areas, and my father, who's a very sensible and brave man, I'm very proud of him, he called my home to say, "Christine, if you want to come home and stay in Abitibi, I can understand. You might feel safer there if you're farther north." So this is a man who I respect so much, who's so courageous as my father is, was worried and even panicked a little bit knowing that I was so far away. So there really was this kind of panicky reaction throughout the country. So when there is that kind of uncertainty, there's sometimes legislation like this that was passed rather more quickly than might usually be the case, because people had across the board were feeling somewhat panicky, including the elected representatives. So that is the case with this legislation. In the bill that we're currently studying, this bill is intended to amend the Criminal Code, so it adds and changes activities considered as terrorist activities. It increases the sentences, particularly for harboring a person who's committed a terrorism-related offense. It amends the Canada Evidence Act, and it also amends the Security of Information Act. It's true that terrorism in its various forms is a threat to our society, and we have to face that fact. However, I think it's always interesting to ask ourselves when we're talking about bills that deal with crime, what constitutes the hard line and what constitutes the intelligent and effective line. Because sometimes the two are the same thing, but other times they're not. So we really need to take the time to really reflect on exactly what it is we really want. And I think we have to always look for the intelligent and effective line of attack. Nowadays, people who are opposed to democratic regimes are rarely from conventional forces as perhaps in the past, but they're more rebels and terrorists who don't respect any rules or conventions, not international conventions, treaties, nor the rules of engagement. for those involved in a war. So I think we have to ask the question, if our opponents don't respect all of those rules, is it not an idea across the way to ask the question, are we ready to abandon these rules in order to guarantee our collective safety? I think sometimes it's worth taking the time to think and wondering if we're not selling our soul to the devil and by accepting things that go too far. By justifying these things and saying that it's the name of collective safety and security. So we have to be very careful when we discuss these issues. Are we going to endanger human rights, individual freedoms that are near and dear to our country and our democracy, and for which people fought? Canadian soldiers fought for that in several wars. And are we going to put what we've fought so hard for at risk? I would suggest that the answer is no. Why? Because this anti-terrorist legislation asks the question, are we currently fulfilling our obligations in terms of our collective security? Anti-terrorist measures have already been taken in the past, and all of these provisions remain in effect today, with the exception of the investigative hearings and the recognizance with conditions. So the sunset clause that took effect in 2007 had indeed been put into effect for those provisions because they had been seen as a short-term solution for an emergency situation and because concerns had already been expressed at the time. So it's a bit what I was saying earlier on. We're coming back to that panicky moment that followed the attacks in 2001. So measures were taken without being 100% certain that those were the ones that should be taken given the atmosphere at the time. These measures, before being suppressed, were never used. They were never useful, rather. They never had been used, and except in one case, and that was unsuccessful. Therefore, today, we want to reintroduce those same measures that were never used and that were set up for an emergency situation at the time. In more recent cases, it wasn't necessary to turn to those particular measures. The current provisions of the criminal code have been amply sufficient. So we are currently in the process of trying people with the legislation that already exists within the criminal code. In 2007, when those measures were sunsetted, the House had already rejected a proposition or a proposal to prolong their effect. Our desire to be seen as interventionist means that we are somewhat losing sight of the whole notion of justice. Our system must not indeed be totally focused on law and order rather than on justice. When we look at the application of our legislation, we can see that the current provisions are already sufficient. On top of that, the responsible committee heard from several witnesses who maintained that the current legislation was sufficient. For example, during the 2011 study by the Standing Committee on Security and Public Safety on C-17, which is the former version of this bill, Mr. Denis Barrette, who is the spokesperson for the International Monitoring Coalition on Civil Liberties, Mr. Ihsan Gardé, who is the Executive Director of the Canadian Council on Islamic-American Relations, Ms. Ziad Mia, who is from the Muslim Lawyers Association, and Mr. James Kafia, who is from the Canadian Islamic Council, all spoke out against this bill, which was useless and undermine various civil liberties and human rights. And therefore, Mr. Speaker, if I may, I will continue with what those people said at the next debate on this bill when you give me the rest of my time, my other 10 minutes. Thank you. The Honourable Member for Abitibi-Témiscamingue will have 11 minutes remaining for her speech and 10 minutes for questions and comments when the bill resumes debate